All right. Good afternoon, buenas tardes, bonjour, bom dia. In the spirit of welcoming this diverse group today, I have a few introductory comments in your languages. Una bienvenida particular a todos los de América Latina, y sean todos bienvenidos, y bienvenue a mis amis de Québec. Mi nombre es Richard Wong, soy socio y jefe del grupo de construcción y infraestructura en el bufete de Osler, Hoskin, Harcourt, en Canadá, Band 1 Practice Rankin Chambers. Eu também sou o chefe de la división internacional do Foro de Construcción da Orden de Abogados dos Estados Unidos. We're very pleased to have in all of you today an incredible mix of civil and common law attorneys, consultants, and experts representing the Americas, including Peru, Argentina, Brazil, Chile, Puerto Rico, Venezuela, Paraguay, Uruguay, Mexico, the US, and of course, my home, Canada. This webinar is a presentation of the ABA Forum on Construction Law, which is next to FIDIC, one of the largest groups of construction lawyers and consultants in the world. Members of the forum's 13 divisions, of which this is one, represent all segments of the construction industry, from owners to design professionals, general contractors, construction managers, subcontractors, suppliers, insurers, and sureties. And as a Canadian lawyer, the forum has been very useful to me in cultivating a strong collegial network of international contacts in the engineering and construction industry. And whether you're in-house or external counsel, consultant, expert witness, attorney, it's really been helpful, as I think all of you have seen in your practices. You have clients going outside of your jurisdiction, and you've got new entrants into the jurisdiction, all, again, with the goal of developing international projects. So if you like what you see today, let me know and I can give you more information on becoming a member, an international associate member of the forum. And I'm offering a limited amount of modest subsidies to help reduce the cost of joining. Ya sé que todos ustedes hablan inglés mejor de lo que yo hablo español, y mutandis mutandis para vocês no Brasil. Pero no, el mensaje es que el Foro de Construcción quiere realmente expandir su red en América Latina. And so this webinar is part of this initiative to have collegial, nonpartisan, and practical conversations about differences so that we can work in good times and in bad when we're fighting on a project or putting it together with a greater understanding of the other counterparties. It makes each of us even better in what we do. So I have the pleasure of introducing two of our division members without whom this concept would not be possible today. Amy Phillips is Vice President of Performance Practices at Thornton Tomasetti in Washington, D.C., who not only helped come up with the catchy title, Bridging the Americas, but also supplied the very apt picture in the brochure and my background. As the webinar starts, Amy will monitor your questions, and please channel your questions as the discussion and conversation goes on in the chat box in English, Spanish, or Portuguese, and then Amy will monitor them and relay them back to our episode 1 moderator, Jerry Brodsky. And Jerry Brodsky is a partner and director of Peckar and Abramson's Latin American practice based in Miami. Many of Jerry's matters involve multicultural, domestic, and cross-border transactions and disputes. And as written up in a fantastic article in law.com just a few months ago in December, this man may have single-handedly saved the $400 million expansion of the Panama Canal from cratering in a complex dispute by bridging cultural divides to earn respect from all of the international parties involved. And so with that, vamos a arrancar. Jerry Brodsky, over to you.
Richard, thank you. And thank you for those kind words. I hope that I didn't blush too much, but thank you. We're super excited to start with our Bridging the Americas series with episode 1, which is Design Build Standard of Care. Episode 2 doesn't have a title yet. I'm pushing for Revenge of the Engineers, but I'm not sure if that title is going to stick. I think that the best way that I can describe what we're trying to accomplish in this series is to tell you a little bit about the criteria that we used to select the topics for these episodes. And it really boils down to two main criteria. What we're trying to do is provide an understanding of how, given the universality of many construction issues, legal doctrines and jurisprudence that govern construction law issues risk allocation, and disputes in construction, how they translate from common law in the US and what we're used to civil code jurisdictions south of the border in Latin America, such as Mexico. And we're privileged to have Roberto Hernandez from Mexico with us today. The second criteria, which is related, but perhaps a little bit more focused on the key and more up to date topics of interest, is understanding what are the civil code considerations of current issues of significant interest to practitioners and to the industry. For example, today's topic, design build standard of care, meets both criteria. We're going to be discussing the standard of care and other fundamental concepts that govern construction cases and allocations of those risks in the US under our common law system. And we're also going to be talking about design build standard of care, which is certainly a subject of significant interest currently to practitioners and to the industry. Our mission is to provide a good balance of legal doctrine and practical information. Some doctrine is necessary to understand the fundamental concepts in civil code jurisdictions and law. So our panelists cover all of these important perspectives, the legal perspective, common law and civil code, and also, very importantly, the technical perspectives. And we'll hear from Nick Saenz on that a little bit later on. So let me spend a couple of moments introducing our amazing panel and ask each of them to tell us a little bit about themselves. First, Robyn Miller. Robyn, she is the General Counsel of CallisonRTKL. Robyn, please tell us a little bit about yourself.
So I've been with CallisonRTKL for about 5 years. Before that, I spent 20 years at AECOM, the last several years as Chief Counsel of the Americas. You know, since I went in-house in 1995 with DMJM, I have been particularly focused on professional issues involving architects and engineers, professional liability, risk management, but in particular a focus on global issues and standard of care. So this opportunity felt right up my alley, and I very much appreciate being invited to this panel.
Thank you, Robyn, and so we appreciate you being here for sure. Bill Quatman, General Counsel of Burns and McDonnell. Bill, please tell us a little bit about yourself.
Thanks, Jerry. Like Robyn, I had a prior life before I came in-house at Burns & McDonnell. I was in private practice for 24 years, representing mostly design firms and construction companies. And then 12 years ago, I came in-house as General Counsel for Burns & McDonnell. If you can't tell by my jacket, we're based in Kansas City, home of the world champion Kansas City Chiefs. We hope to be the repeating world champions in a few days. But we are an integrated design build company. What I mean by that is we have in-house design and construction personnel and services. We offer probably 90% of our work is done design build, not only in the US, but across the globe. And we have about 8,000 employees. We do about $5 billion worth of revenue a year. And we are listed in the top 10 design build firms in the country, as well as in pure design firms.
Thank you, Bill. And remind us, you're a former chairman of the Design Build Institute of America?
Correct. I was chairman of the board of DBIA, the Design Build Institute of America, and served on that board for 8 years, and just recently finished my term there.
Thank you. Thank you. We very much appreciate you being with us here today. Next is Roberto Hernandez. I could give Roberto Hernandez his background and do his part for him. Why? Because Roberto and I have been joined at the hip and been colleagues and close friends for a good number of years. And I've had the pleasure of growing up as a lawyer on a very close and parallel track with Roberto. But I think that you'd probably prefer to hear directly from Roberto. So please, Roberto, thank you for joining us today, and tell us a little bit about your track and background.
Thank you, Jerry. Thank you very much. I'm very pleased to be here. Thank you, Richard. Amy, and all of the panels. I'm excited to be here. I'm Roberto Hernandez. I am a construction lawyer and construction neutral, have been a member of this extraordinary group, the Construction Forum, for more than 15 years. I'm managing partner of COMAD. It's a law firm in Mexico that works in construction and infrastructure projects in Mexico and Latin America. We do also public procurement and anti-corruption. I'm a very proud member of the American College of Construction Lawyers and advise several organizations in Mexico and Latin America in engineering and construction. And I act also as dispute board and arbitrator in construction engineering projects in Latin America. So I'm very pleased to be here. I'm very look forward to really knowing and receiving all the inputs from our wonderful panelists. Thank you very much, Aaron, everybody.
Thank you, Roberto. And briefly, I'm Jerry Brodsky. I'm with a partner at Peckar and Abramson, and I head the American Practice Group. I spend my time with one foot in the common law world in the U.S. and the other foot in the civil code jurisdiction south of the border, working on matters in Latin America. And I can tell you that both worlds are in constant state of flux. So I tell people I'm kind of like a legal expansion joint. That's pretty much describes my path. So without further ado, I'd like to start the conversation by really hitting the topic of our episode head on and defining what we're talking about when we say design build and then design build standard of care. Let's start with design build. Bill, if I may ask you to give us a little bit of background on the definition and the distinguishing from the traditional models, and also different types of design build arrangements that have evolved over time.
Thanks, Jerry. I think the single defining key of design build from other types of delivery is a single contract for both design and construction services that's entered into between the owner and one entity. Now, that one entity could take several forms we'll talk about in a minute, but that is the one thing that differentiates it from design bid build, where there's a contract between the owner and the design firm, and then a contract between the owner and the constructor. Design build marries the two together under one contract, single point of accountability, single point of delivery, which survey after survey has been done, and owners say that's the #1 selling factor of design build. It's one phone call to make, one entity to deal with. The variations under that essential definition are these. An integrated firm like my own, Burns & McDonnell, where we offer everything in one roof, and a client hires us to provide design and build services with one company. Probably the most popular way to deliver design build in the US is through a prime subcontractor relationship, where the owner hires a design builder, and the design builder then subcontracts with trade subcontractors on the construction side and with design professionals on the design side. But in terms of the owner, it's a single contract, single point of responsibility. Now, that can be delivered with a general contractor holding the prime design build contract, which is the most common in the US. But there are some design firms that will hold that prime contract as well and subcontract to a general contractor. It's less common here, but it is done in some markets. The third and final methods, we've integrated prime sub. The third will be a joint venture. And this is done in some markets in the US. I think it's done more internationally, but this is where a designer and a constructor come together and form a joint venture, a type of partnership for a single project. And the two of them then allocate design and construction responsibilities between them in the joint venture agreement. But the owner hires a joint venture, a JV of one entity comprised of two partners. Jerry, back to you.
Thank you. Roberto, let me pivot to you. Having had Bill lay out the different variations of the design build model, Now we have not only design build, but we have flavors of design build. How does that translate? What's been your experience thus far in Mexico in terms of the incorporation of the design build model as a project delivery in your jurisdiction?
Thank you, Jerry. I would like, besides talking to Mexico, I have the caution to speak with also some of our colleagues that are here, and we welcome them from different countries and also some places where I have experience. Let us remember that the civil countries have specific conditions that, as we have spoken with the panel, are very different than the US. First, of course, we cannot generalize what happens in the civil countries because we have 33 civil countries in Latin America, so that is a lot of practice, a lot of things, but most of them have like a differentiation that can be very clear: private contracts and public contracts. The private contracts are regulated by commercial and civil codes, and public contracts are regulated by public procurement and government contract laws. And this is a very important distinction when we spoke about design build, because as I have lived and I have spoken with several colleagues, for example, with our alliance in Counsel Legal, there is no just one solution. But for example, in private construction projects, we will see a lot of design build schemes when the owner gives to only one company this kind of obligations and duties from design and construction, giving, as Bill said, all the burdens of the development of the project. However, I have seen in Mexico and in Central America and in Latin America, as I have been speaking with our colleagues, that when you speak about public contracts, only with the exception of very, very specific and technical projects like the ones that petrochemical or very specific and technically specialized, you will not see design build. You will see this, that the government engages a design firm, and then from that design, they bid the construction to one or several companies. This was the case, for example, and I'm speaking on a mega project of the now canceled International Mexico City Airport, which it was given to a very large design company, and then it was given to the construction companies. Other kind of projects like this work similar in highways, in stadiums, etc., where the design is given by a very specific designer with a specific capacities, and then they give it to construction contracts. We were also speaking, which is very interesting, is not only a law matter, but in civil jurisdictions, it is, and in Latin America, the economy is very different. So, for example, you will not see, with some exceptions, these very large companies that can take out and carry out design build structures. On the contrary, you will see design companies and construction companies, because in some years ago, when there was some crisis, the companies that had these both units had to diminish in the design, because it was given by the government to other companies, and then they were focused on construction. So we have a very clear case, for example, in Mexico. It is a company, the flagship company called ICA, that used to have a very powerful engineering unit, and since the government decided to avoid engineering, they had to diminish this unit, and in fact it disappeared at some point materially, and they focused on the construction side. As we spoke, there are several companies now in Latin America that just focus on the construction after the design. So how are these obligations given? And what Bill said, they are given on a contract. Of course, if it's a private construction project, you will rely on the contract. So you have to have this negotiation leverage to determine the obligations and the duties. Of course, using the natural reasonable burden of the risk for each allocation of the risk. When you speak about public projects, you may have a different situation because it's not just the will of the parties as it is on private construction projects, but it depends on the public procurement laws. Most of the public procurement laws in Mexico are mandatory and they are not subject to any negotiation. So you have to rely on what is said. And usually, as Bill said, you have a joint venture or a company. And if you have a joint venture, for example, in this kind of public procurement government contract entities, you have a joint and several responsibility for the designer and the contractor, which is very, very tough, especially for the designer. So these are the kind of things that I can tell you. I will stop here to keep the conversation, but these are the main principles that I would like to speak about. Thank you, Jerry.
Thank you, Roberto. I had a follow-up, just curiosity if there's any trend. In the case of joint ventures, when joint ventures are formed in Mexico for a design-build project, do you tend to see, and in the cases where one of the entities is local and one of the entities is foreign, for example, in those situations, does the foreign entity tend to be more often the contractor and the local entity the designer, or is it vice versa, or is it there's no trend? What's been your experience?
What I have seen, and I'm speaking right now about Mexico, that the trend is that in complex projects, the designer is an international designer, and the contractor could be a national contractor with, for example, an alliance or a consortium with other contractors. And for example, in the airport that I was speaking, or right now in the Tren Maya, which is a very important and relevant project in the south of Mexico, you will see that there is a design, and the design is made from international companies. And that doesn't mean that they have not a base in Mexico or elsewhere. They are international because of their origin. They do the design, and then there is this bid for construction companies. And depending on what are the requirements of the owner, then they can join and they can with other international companies or not. But being very straightforward, I think it's more international design and local contractors construction.
Okay, well, one more follow-up then, if you don't mind, Roberto. I mean, with Mexico in particular, and a lot of Central America and South America being such as seismic areas, the reliance and the importance, I would imagine, of the local engineer, the local designer that is familiar with local seismic conditions, how does that figure into your description that the international designers tend to be more prevalent in joint ventures? Do the international designers then have to rely on a local designer for that guidance? Is that regulated? Is that mandatory? How does that work?
I would say it is not strictly regulated, but I can tell you about the typical example that you will hear. Mexico as a whole is a seismic area. So you will have to rely on very local experts on this. And the classical example I was telling you is, for example, the California codes, that people say, well, we are using the California codes. Well, but some codes in Mexico could be different, even if they are more stringent in California. So you have to really work on the place. There are specific regulations on every place and location related to seismic codes. So it is important, I would say, for any designer and even for the contractors to have a very specialized engineer, expert that could give the specific matters on seismic codes, because also some of the standards and the regulations and the practices on Mexico regarding seismic have been changing. And let me put just a very, very typical example. In Mexico, not all the municipalities and the states have seismic codes, But for example, the National Commission of Electricity have a manual. This manual is not a law, this manual is not a regulation, this is not a standard, but many projects use this seismic code as a reference. So we were involved in a case when the company was not aware of this manual, and right now it's a litigation. So we have to go and really know on the practice and the people that really know about this on specific places, besides the natural design duties.
One more question, Roberto, on this topic, and I promise I'll move on. Is it possible to have a situation where project specifications that come from abroad into Latin America, for example, that are developed by an international design firm, could the specifications require in the seismic code a higher standard than the local seismic codes?
Do you mean if they are higher? If they are
Yes.
higher? Well, this has happened in the sense that some owners said, I want to use the standards that are applicable here. If they are really clear on the bid or the contract or what they say, some clients are not experts, and they will also only rely, even if the foreign are more stringent, they will say, I want the codes that are applicable here in order to develop that. I think that is, I don't understand it really, because I know that if you have more stringent codes, it is better for the owner, but we will speak about, for example, the standard of care, and that means that we see the things in very different ways, and sometimes we're very literal on what the owner is asking and how to be obliged. So I would say that we have to be very cautious on what is the request of the owner, how do you perform this, because under these conditions, you will comply with the contract or not. So we have to have a lot of communication with the owner in order to see if it is possible to use that standard. And this case, the litigation I'm telling you is related to they are using international standards, but the owner is saying, no, I asked for national standards. So it's a little bit complicated. And as you know, our litigations don't give the stare decisis that we were speaking about. And each case gives a different condition that may be not general for the rest of the industry. So I hope that I get my diploma for this test.
Well, thank you, Roberto. And what you've done, thank you so much, because what you've done is provided as a great segue for the next part of the discussion, which is the discussion about risk allocation and standard of care. I'd like to do what we did before for this segment, and I'd like to ask Robyn to paint the canvas, the U.S. common law canvas for us on risk allocation in build contracts. Take it away.
Thanks, Jerry. I think I'm going to start by just talking about the standard of care, which if you're a U.S. lawyer under common law, this is a concept that you live and breathe if you're in the construction industry. But if you're not used to the common law, it can be a little unusual. Simply stated, the standard of care is a community standard, and I'll talk about that in a minute, for determining whether an architect or engineer has met their professional obligations. In other words, it's not a code or a law that determines whether the architect has done their job. It's the standard of care. And that standard of care under common law is not perfection. Instead, architects and engineers are expected to perform their services with the same level of care and skill used by other architects and engineers, providing the same or similar services under the same or similar circumstances in the same geographical area. Why is that important? That's important because it means that the standard that's applicable to architects or engineers that are practicing in Alaska is going to be different than what's expected from an architect or engineer that's designing in Florida, because they're different geographies with different requirements. And, it was interesting listening to Roberto talk about the seismic requirements, in Mexico. And obviously, from a US standpoint, you need to be familiar with the requirements in the geography that you're practicing in. It also means that the standard that's expected from an architecture engineer who's maybe designing a healthcare facility is going to be different than somebody who's designing a warehouse. It's a matter of your expertise in applying what you know how to do. And I would say that the expectations for a designer in a design build project are going to be different than a designer who's designing a full set of construction documents in a design bid build sense. Talking a little more about the standard of care. The standard of care concept has been part of US common law for more than 120 years. It's interesting because through case law and stare decisis, it's been reiterated in a number of law cases, but it actually hasn't changed that much from one of the earliest decisions 120 years ago. And in that case, the court ruled, that an architect needs to have the skill and ability sufficient to enable him to perform the required services, and that he apply that skill and ability, but he's not implying or warranting a specific result. And specifically, the court added that an error in judgment isn't evidence of want of skill or care. Mistakes and miscalculations are incident to the businesses of life. In other words, the standard of care for architects and engineers is not perfection. And similarly, for many of those on this call who are lawyers, I know will appreciate, at least in the United States, a similar standard of care is applicable to lawyers and doctors. In other words, you're not expected to be perfect. You're expected to do it in accordance with the standard. I want to go to the second part of Jerry's question, which was really, how does the standard of care affect risk allocation for changes from the bid design? To be blunt, it means that an architect or engineer is not necessarily going to be liable for increase that come between the time of the bid design and the final design, if there's missing information or changes, provided that the architect or engineer acted consistent with what other professionals would have done in the same situation, in the same location. And I think that determining the standard of care and design build is particularly challenging, because by nature, the design that the design builder is going to base their bid on is usually about a 30% design package. It's not a full 100% construction set like what you would get in a traditional design bid build circumstance. So if there is a dispute because the contractor his bid is too low because there wasn't enough information in the design documents, there's going to be a lot of dialogue around what should have been in that 30% set of drawings, and what wasn't in the set, and what would have been expected for the contractor, and should the contractor have expected to have some of those anticipated costs, knowing what a 30% bid set is. As my colleague Nick will discuss a little later in the program, determining whether a designer met a standard of care is usually determined based on expert witness testimony. And each party will retain an expert who will opine on what the standard of care was, and compare that standard of care to how the architect or engineer in the particular case performed.
Thank you. Robyn, I have a quick follow-up in the contract exercise when parties try to define the allocation of risk in design build. We've talked about community standard, and my question is, in your experience, can the community that is used as the baseline reference be contractually defined and modify the community at common law?
The answer to that is yes. The common law standard is implied, but actually it's something I think you need to be very careful of if you are, an architect or engineer or an attorney for an architect and engineer, because if your contract has a different standard in it, you're going to be held to that different standard. So not only can a contract confirm what the common law standard of care is, which is to state again that it's what other architects and engineers would have done under similar circumstances in the location of the project. But you can define a standard of care for a contract that goes beyond that. And in fact, very often we see clients trying to push for a different standard of care, and in some cases even going so far as to say that for design bid build projects that your design has to be 100% complete with no errors, which of course is not realistic in the way that architects or engineers work. And what that original design package is in a design build project, that standard of care can go to define, in the contract can go to define more clearly what does and does not need to be in that design set. And then, if you have those things in your contract, that's what's going to drive what you're measured against, not the common law standard of care. And it's a reason to be extremely cautious, because generally professional liability insurers insure to the common law standard of care, which is that you're performing your services the way other architects and engineers would under similar circumstances. So if you agree in your contract to other terms that would make your services subject to additional criteria, you may risk not having that claim covered by your insurer, because instead of going with the common law standard, you've gone with something higher or different.
Jerry, can I comment on that? This is Bill.
Yes, I was hoping.
I agree with Robyn. We see some owners' attorneys will put in the contract that will perform to the highest standard of care, or a standard equivalent to the best or top engineering firms in the United States. And I think the attorney for the owner thinks they're doing their client a service by pushing that standard of care higher. As Robyn pointed out, the insurance policies only insure to the common law standard. And if the attorney is successful in getting the design firm to sign that contract, and there is a claim, the insurance carrier might very well deny coverage and say, we don't insure to the highest and best, we insure to the average firm, the typical firm. And then the lawyer has to explain to their client why they just voided the insurance policy that the client required the AE firm to carry. And that then becomes an attorney's malpractice claim. I think that's the message Robyn and I want to send to the owner's attorney. Don't be too clever for your client and then eliminate coverage for the design firm.
That's Bill. That's a great point, and it's zooming out and looking at the bigger picture is always essential, and that's what you've just done. Thank you for adding that perspective. Robyn, I'd like to zoom in a little bit more with you on the practical impacts of the standard of care and the attempts to deviate by contract from standard of care. In other words, does every breach of contract or every contract non-compliance constitute a violation of the standard of care, and vice versa?
Yeah, I would say no. I mean, particularly from a breach of contract standpoint, particularly if you have a clear standard of care statement in your contract that governs your performance, that things that go to performance in terms of breach of contract are going to be viewed through that lens of standard of care. But I do think that what happens is that people often tend to think that standard of care can just be like whatever the most persuasive expert says it is if you get into a dispute. Whereas what Bill and I think are going to talk about is that, in fact, there are very clear benefits of a standard of care, and there are very real life consequences that come from it. So the first one that I'm going to talk about is in 1994, the Northridge earthquake hit Southern California. There was widespread damage to high-rise buildings all across Los Angeles. In particular, there were numerous fractures in the beam column connections in steel moment frame buildings, which is what most of the high rises downtown were. At the time that those buildings were designed, which was largely 1964 to 1999, there was a material made by Lincoln manufacturers. It was a Lincoln E70T-4 welding material. And that was the welding material that that engineers almost universally specified for welding moment frame connections. But it was clear after the earthquake that that even though that's what the engineers specified, it didn't work. Those moment frames cracked. And so the question was, it was clearly what was specified was not sufficient. So the question was, were all these engineers, liable for the kind of damage that came from that specification or specified material not being sufficient? And the answer is no, they weren't liable, because when you looked at the standard of care, they did it the same way other people would do similar projects, high-rise buildings, under the same circumstances in the same location, which was Los Angeles. They all did the same thing. And so because of that, the standard of care said, yes, your specification wasn't sufficient, but it also didn't fall below the standard of care. So that's sort of real life example number one. And I'm going to turn it over to Bill, who's going to give another real life example.
Thanks, Robyn. When I was in private practice, I represented a structural engineer in a lawsuit in which the house he designed collapsed. Now, the house completely collapsed and fell down a hill. The unique facts in that case were there were several houses built along a ridge on a hillside overlooking a small stream that flowed below. During heavy rains, the stream rose and the hillside began to erode. And as it eroded and eroded, eventually the houses sitting on the top of the hill all slid down the hill. Not just the one my client designed, but every house on the hillside slid down the hill. And what we found is that the houses were all designed by different structural engineers. And as Robyn said, the standard of care is what would another engineer do in the same or similar circumstances. We had the exact circumstances. A house built on a hillside, and all of the engineers designed drilled pier foundations through the fill dirt down to bedrock. The purpose of the foundation was to hold the house up, not to hold the hillside back. And when the hillside slid, the drilled piers simply snapped and all the houses went down the hill. I took that matter to a dispute board. The state licensing board in Kansas had a disputes board, and that board concluded that my engineer was not negligent because he did what every other engineer did in the same or similar circumstances, which is design the house on drilled piers to bedrock. The house failed, but not because of any negligence, at least in the eyes of the law, on that engineer's design.
Thank you, Bill. I think that both examples illustrate for lack of a better term, sometimes unpredictability of this issue of standard of care in design build situations. There's not any objective criteria, and by definition it is a fuzzy and sometimes not absolutely clear boundaries of liability. With that state of matters, we're going to turn south and ask Roberto. Roberto, you've just heard Robyn and Bill explain how you can have a situation that would, for most, come across as some sort of a violation. So this house slid down the mountain. Somebody must have made a mistake. It would be the natural reaction, and yet you're hearing Bill tell us how there was no negligence finding in that situation, same as in Robyn's example. Anything like that? How is the issue of risk allocation in design build projects addressed in civil code jurisdictions? Can you draw a contrast for us, please?
Yes, I think in general, the responsibilities of the designer and the contractor are, if this is split, is very clear in every situation. However, it can vary. And what Bill said, although I read some comments, but what Bill said is very important. If we establish in our contract some provisions that are not really clear under civil law, it may generate some complications. For example, and I'm go back, under civil law, the contracts, and I'm speaking about private contracts, are ruled and governed by the commercial code and the civil code. So the commercial code and civil code in most of the Latin American countries are very similar. And you will see that the will of the parties is the essence of the obligations that derive from the contract. So if there is anything that reduces or increases the responsibility of the designer of the contractor because of any negotiation, that will at some point affect this kind of results of who has the risk allocated. So with that that being said, the first thing we have to understand is that we have to be very careful in order to put in our contracts or write in our contracts what is the responsibility of the designer and what is the responsibility of the contractor based on the contracts. Of course, if we are speaking about public contracts, there's a different kind of rules in which those contracts are differentiated, as I told you previously, because there is a design contract in the first phase of the project, and there is a second construction contract in the phase of the construction. Now, there is a very interesting thing that is happening in Mexico, and we have here some Mexican colleagues, engineers, who I say hello. We have in Mexico City a problem in which there is like the officer who spoke, the construction officer, the DRO, in which according to the construction regulations is responsible for most of the matters of the project. So with this, I'm not trying to tell you about the officer's duties and obligation, administrative matters. What I'm saying you is that at some point, because of the current regulations of the construction rules in Mexico City, the officer will be ultimately liable for the design and the construction. We are working very hard for this not to happen, because you cannot rely all the project in only one person. But at some point, all these kind of mixtures give the essence of the risk allocation. What we are trying to do in this reform, because it's a special group that we are working on, is to give specific obligations and duties and responsibilities for the designer, for the contractor, for the material supplier, and in general also to the DRO, but in their own sense. So we are fighting in this kind of responsibilities. A final comment that I would like to say is that, as you know, in civil law countries, very few decisions come out as a general criteria, and most of the construction cases are not settled and don't go out as a jurisprudence, which is our equivalent to stare decisis. So we don't have a general criteria that we could use in order to be able to define these obligations, and it's very, very tricky. So we have to work on the contract, on the regulations, on the construction regulations, and the general situation of the contract of the project according to what it is being done.
Roberto, thank you. In the United States, at least in Florida, we have a figure which is in some way similar to the DRO, the Director Responsable de Obra,
yes,
that you mentioned, and that's the threshold inspector. But you and I have had long conversations about the differences and how so much bigger the exposure of a DRO is to liability and responsibility than your typical threshold inspector. Especially, you've told me before, so there's been instances in which DROs end up in jail and have criminal responsibility. Is that correct?
Yes, that's right, and that's very important, because you cannot put on only one person the whole risk of the whole design and construction and everything. So this is something that the engineers that are authorized for that purpose are fighting for that. And this is very important, because this is not only the officer's situation, but some designers and contractors will not be as careful as they should, or the responsible they should, because they know that at the end they will not be wholly responsible for that situation. Of course, you can have civil and commercial conflicts from one party to another, for example, the owner to the designer. But we have seen cases, we haven't had directly the case, but we have seen cases that have raised when the owner sues the contractor and the designer, and ultimately the DRO is under the judge given the decision that he's responsible for that. And that is very, very ugly situation. No?
I can understand why you are trying to change it. Before we leave this topic, I want to ask you, and your answer will share a story that we experienced together, and that is, and perhaps many practitioners as well, where situations where you have a U.S. company that is involved in design build, whether it's the contractor side or the designer side, and has done it for many years in the United States. They have their standard contracts, and they have what they've come up through experience with their comfortable risk allocation language in their provision of their standard contract. And they come to you and they say, okay, this is what I want in my contract for my project in Mexico. I'm comfortable with this risk allocation in the United States. Can you translate it? What's your response, and how does the beginning of that horror movie start?
Well, let me tell you something. I have been very, very fortunate, and I'm being really honest, to be part of the ABA for many years. And I have heard a lot of things, and I have learned a lot of things thanks to American Bar Construction Forum. And I'm familiar to many concepts that you never hear in Mexico or Latin America. So I'm fortunate. I'm not saying that I'm the only one who knows it, but it's my source of information and knowledge is the ABA. So, for example, I'm not unfamiliar with the standard of care clause, but when it comes down to a contract and you try to use this text, as Robyn said, that the consultant or the designer will perform in the degree of care exercised under similar conditions, but professional consultants on the same field, the same time, the same locality. When you've said this, the other party says, what are you meaning? What do you mean? This doesn't mean anything. What do you mean with similar conditions? What do you mean with similar profession? What do you see with same field? And although, while Robyn said this has been a 100 years institution, in Mexico at least, and I know that any other countries, you will not see this institution. So for example, you will use what we call parameters of design. And it is at some point clear, the parameters of design is what does the client require, what is expected, and what is delivered. So what is required, I will give you this project that has to be this characteristic under these conditions. I expect you to do this and then to deliver it. This comes, of course, this doesn't mean that doesn't give conflicts. We speak about, for example, the difference between the interpretation of how detailed the design has to be. And there is a very important difference of what the detail of design in the US than in Mexico. And of course, also you will get to the concepts of fit of purpose, for example, because some people confuse fit of purpose for the guarantee of the result. And that is something that is very well understood in the US, but not here, because we are mostly used on parameters, number, documents that you will be defined on what is your complaint. Robyn said exactly the example, the 100% or bill is 100%. And 100%, what does it mean? Everything that the owner wants, everything that the owner is satisfied, or what it is customarily under the industry. And that is also a matter of further possibility of litigation. So at that point, you have also to be clear, state the specifications on the contract, and determine as much as possible, according to this principle of commercial and civil code, that the letter of the contract rules the intention. So as much possible, the clearer the contract is, you will have less possibilities of interpretation, and then to satisfaction and deliver to the client. And that is, I think, is a very important difference. How do you deal it? I think just by negotiating, explaining. We had a case when this statutory, this the rule, the clause that we spoke about, we tried to include it in a contract, and we ended on specifications and things that were equivalent, but not exactly what the clause of this said. What is the result? So it is a matter of really trying to not only to translate the terms from one language to another, but the concept. What do you want is that the designer or the contractor, especially the designer, the build designer, you have the possibility to determine how will your client be satisfied according to the requirements of what is established in the contract, differently than what is established in the regular clause of performing services in connection with similar conditions, etc., etc. So it's a tough situation, and you may get possibly the risk of having a client that says, well, if you cannot get this, this is something that is your problem. But you have to be very open to your counterpart and your client, trying to translate in concept and put in your clause what they want, maybe in different words. And I think that would be my suggestion.
Thank you, Roberto. Thank you. In my notes, I had a note to ask about licensing, and I wanted to ask Bill, when you guys do design build work in many parts of the world, are there any specific licensing issues that you run into when you are doing projects outside of the U.S.? This is kind of related to the question about the seismic engineering and that Roberto was talking about, but from the U.S. designer standpoint, what are some of the challenges you've encountered when you head south?
Well, thanks, Jerry. And it's not just in the South, but in the U.S. as well. I think licensing is an issue that a lot of attorneys overlook when they are advising a design build firm or an owner on design build projects. In the U.S. 25, 30 years ago, there was no licensing law that dealt with the concept of design build. Some states license contractors, all states license architects and engineers for their separate services. And in design build, when they combine design and construction into one contract, there began to be court challenges where very clever owner attorneys would say, this is an illegal contract because the contractor is practicing engineering without a license. And we have a split body of case law in the US on that topic. Some courts held, yes, a contractor cannot offer design build services because they're practicing either architecture or engineering without a license, and they voided the contracts. In some cases, required restitution to be paid back. In other cases, they said, no, it's fine as long as a licensed engineer or architect does the design work. And at least one case I'm aware of, the court split the contract in two and said the construction side is legal, but the design side is illegal. And the constructor can recover for his construction expenses, but not for his design services. Fast forward to today, more than half the states in the United States have addressed this topic by statute or regulation, and they have codified in the statutory law in the US how design build is delivered in that state. When we go to Canada, Richard knows, 11 provinces and 3 territories, they may or may not have dealt with this topic up there. And in foreign countries, it may not have been dealt with at all. But the first thing we do is look to the local licensing requirements. And in some cases, we have to form a separate entity to do work in that jurisdiction. But we're always very sensitive to the licensing requirement for this reason, that very commonly in the United States now, lawyers are aware that that license can be used as a way to avoid paying the design builder. And there are more and more cases where licensing is used as a sword rather than a shield to prevent payment of a just obligation by the owner. There was a major case in the US just in the past few years where a very large design firm was licensed and let its license lapse for 1 day during the project. And the owner then sued to void the entire contract and said, your license was void, and for a single day, you were unlicensed, and therefore the entire contract is illegal. And the court agreed with that, by the way. Very dangerous to not renew your licenses timely. So I have a paralegal that does nothing but full-time renew our licenses in the US. I have another paralegal, and a part-time job for her is to review licensing in foreign countries. So that's a long-winded answer, Jerry is saying. It's a very important issue. And the people on the call would be wise to do some research on that before they start advising design builders in the US or abroad.
Thank you, Bill. So far we've heard from lawyers on the panel. Not that there's anything wrong with that, but in the design build world, there's lawyers and there's also engineers and there's consultants. And we have Nick Saenz from Thornton Tomasetti with us today, who is going to provide some of the technical perspective from an expert's point of view on some of the issues that we've been discussing. So, Nick, please tell us a little bit about your background, your experience, and then I'll ask you a couple of questions so that you can give us the consultant's perspective on some of these interesting topics. Nick.
Well, thank you, Jerry. I'm an associate principal for Thornton Tomasetti. I joined about 8 years ago, and I have experience in design and forensic investigations on a firm. It's a large engineering firm. We don't do construction, but we just do design worldwide. So we have experience in many markets, including Latin America. So I wanted to touch bases on something that Roberto was actually mentioning about the DRO and the different regularities, in different countries. I'm from Colombia originally, so I know a little bit of my country, how is the practice and how is the civil law apply to experts and consultants. And I think one of the biggest challenges we have in general, it is the lack of design codes, for example. The contracts can tell you you gotta do X, Y, Z, but the practices are so unique in every country and in regions within the countries. Mexico, for example, has a very robust code in the city, but as soon as you go out of the city or the state, the Mexico state, everything changes drastically. You don't have any codes, or you have very little life safety codes, but nothing on the building side, and people interpret or start using other codes. As you mentioned, the CFE code, it is vastly used in the country, but it is not a code, it's just a guide. but it is seen as a code. So the interpretation is that in Argentina, I had a case where back in the days, the original code was written in 1944. And the case that I handled was in the mid-2000s, or 2010, 2015. And we were using codes that were written, in the 40s, where it's almost like a constitution, right? Everybody can read it and agree with the concept, but there is no real interpretation of what you have to do, just whoever has a better argument. So there was a lot of, now it has changed. Argentina has issued a new code and it has regulated a little more, but it depends also, it leaves a lot of the interpretations to the building department, if there is a good building department, or the expertise of the reviewer, and the custom practices sometimes of the individual. So that's very challenging too, when you kind of measure, even when you're designing, or when you're trying to judge somebody else's design and the potential failure, it is very difficult to judge on what maybe that particular reviewer was saying that was okay, and why, you know, something was done one way and not another. So the DRO is a big challenge in Mexico for sure. It's a concept that is difficult to understand if you have practiced in the US only, like myself, but I've been exposed in Mexico many times, cases and designing over there, that it is a concept that it really it is very challenging if you want to be a DRO. I mean, if you think about the ratio of DROs in Mexico City versus designers, I mean, it's very small and it's very limited. So sometimes you end up using the same person over and over and over because he's the only person that wants to take the risk. I mean, you know, go ahead, Jerry.
So Nick, thank you. For sure, in some, at least in some jurisdictions, conditions are very different, and we've all experienced things south in Latin America jurisdictions that are very, very different than what we're used to in the United States. But let me ask you this. When you have an assignment on a project as a consultant in Latin America, is your approach to how you investigate, how you prepare the assignment, are there any differences based on these different conditions and situations that you experience? Let me give you an example. Record keeping and project documentation tends to be not as I would say as complete in many projects in Latin America, in my experience, compared to projects in the United States. That's a general observation, not in every single case. So if you're going to have an engagement where you already know that it's very likely that the project documentation is going to be scant and not as robust as you would see in a different jurisdiction, does that change your approach, or do you go into it with that mindset and have tools and techniques to deal with it and to deal with those issues?
I mean, I've been exposed on cases where the practice is very close to the US, as you said, so you have a good share of documents and there's good documentation. Normally, in my experience, that has happened when there is maybe an international company behind the case. So they try to keep records in a different manner, but when it's a local case, those records, as you said, are not normally available or are not required to be disclosed to the other party. So as a consultant, sometimes I cannot rely upon, I'm going to be finding information, let's say through discovery as requested from, from the lawyers. I will be relying upon reports only, and what information it is limitedly mentioned or disclosed in those reports. Other issues that we have, or I have had, is preservation of evidence. For example, a very big challenge. I had a big collab case where in 2 days, they removed all the steel and all the pieces. And we were lucky that some field engineer for the insurance company actually saw a couple pieces, and he took those pieces and saved them on the side of the riverbed. And it resulted to be that those pieces were kind of the key of the puzzle. But otherwise, the entire evidence would have been thrown, and we would just basically would have lacked any kind of evidence to rely upon, any testing and so on. So the discovery of documentation is very challenging. Sometimes it's very open. Most of the time it's not there. Evidence, it's all evidence, I think, also happens in the US. Sometimes it's very it's very challenging, but seems to be less understood the way the procedures may work over there. That's in terms of the evidence. I don't know if you have other examples that I can weigh in, or in respect to that, to the evidence, something you have seen from your experts.
I think that the examples that you've provided are illustrative of situations that we practitioners find also. So definitely, I'm sure that many people that are listening to you right now can relate and have seen those situations. We're getting close to the end of the time allotted for this first episode, and I want to think that we have accomplished our mission in the sense that we've discussed the design build model as it is in the U.S. and in common law jurisdictions, and then contrasted the model itself with civil code jurisdictions. We've talked about the standard of care, one of the key concepts of American jurisprudence, and Roberto has translated the concept, not the words, but the concept and the standard to its applications or applicability in common law jurisdictions. And then we've also heard from Nick, who has given us some practical perspectives with respect to some of the differences and issues that in his experience as a consultant he's run into in projects in Latin America. So before turning it over for comments and questions, I'd like to ask everybody around our panel for some final thoughts, starting with Robyn.
Well, I think the one takeaway that I had listening to both to all of the other panelists is that, you know, under the standard of care concept under common law, you know, it's a community standard, so it's not a clear line as to what an architect or engineer needs to do in their contract. But I would highly recommend for that, and in common law countries, that having a clear scope of work, clear expectations, clear things, even as Nicolas mentioned, on what records need to be kept, that the more things can be tied down and that the parties can have clear expectations on both sides, the better outcome you're going to have, dispute or not, under both common law or civil law.
Thank you, Robyn. Bill, final thoughts.
Well, I think one topic we haven't drilled enough into, and I'm just going to put this out there, is in design build, unlike design bid build, typically the constructor is putting a fixed price on 30% complete design documents. And that is really where the real risk is in design build. With design bid build, you have a fully developed set of plans and specifications. They've detailed everything down to the doorknobs and the paint colors and the ceiling tiles. But in design build, often, as Robyn said earlier, you have a 30% set of documents, and on that, the contractor is putting a firm fixed price upon which the owner relies. And that requires a lot of skill on the contractor's part to interpret that 70% missing design. It requires clear communication between the design firm and the constructor as to what the expectation is and the deliverable of that 30% set of documents, what's in, what's out. And the disputes that I've seen have been primarily around that issue in the US. I suspect it to be the same issue in foreign countries, that who carries the risk of the incomplete design. Contractors want to push that to the AE firm, AEs want to push it to the contractor, and it is an inherent risk in design build.
That's great segue, Bill. Thank you, Roberto. What's your takeaway with respect to Bill's the issue that Bill's discussing?
Well, I wanted to share something, if you don't mind, not exactly related to Bill's, but my takeaway would be, if you are in Latin America and you are not familiar with the standard of care and all this kind of thing, related concepts, don't get scared. And if you are part of the US company, please know that there are some other solutions according to the civil law and Latin American practice. This means that there will have to be an effort. And I think the title of this program is very clear, the bridge between both. Because at the end, the design is the design, construction is a construction. What happens is, as now I will say, as Bill says, that you have to determine when it is the design complete, when it's fulfilled, and this criteria may change. So you have to be very careful on what are the expectations, for example, of a Mexican client, and what are the expectations of the US company in performing the contract and fulfilling it. So have to have a lot of communication and not presume that things have to be as in the US, or for Latin American clients or Mexican, things always have to be like we do it here. We have found a lot of efforts and exercises where both kinds of efforts, US and local practices, do a better practice. So I think there's a lot of communications and expectations have to be clear when you have different languages, different cultures, different standards, in order to look for the success of the project. And that would be my takeout. Thank you, sir.
Thank you, Roberto. Nick, takeaways, any final thoughts for the group?
I mean, in terms of on the engineering side, when you're working on foreign markets, for us at least internally, it is always accustomed to have, we always team up with a local consulting firm to help us understand those local practices and ways of designing and working together, so we minimize liability in that way. So, you know, if you are practicing in those markets, I would say, you know, don't go on your own at the beginning. Try to learn what the market is and what the local conditions are before you go deep into it. Similar to the US, we don't jump states just for expanding, but we need to know what's the practice in every place, every city, and so on.
Great, thank you. One follow-up, Nick, that I had, that I wanted to run by you to see if you've run into this issue, and it's related to what Roberto was talking about before, and also to the differences in legal systems between common law and civil code. In a project in the US, the project records, save for very rare circumstances, are always going to be discoverable. You as a forensic expert will have access, or should have access, to all of the project records that exist. Mm-hmm. That's not the same in Latin America. You may not have access unless a judge orders it, or an arbitration panel orders it, to records from one party, from the adverse party. So you have less information. How do you supply the missing information? Where do you draw from to form your opinions in situations where you don't have enough information compared to a case in the United States?
I mean, that's always a challenge. Normally, what we've done in the past is, you know, we try to use common standards and try to prove indirectly that maybe this individual committed, you know, some sort of negligence in the design. But when we don't have all the information, it is very challenging to really point out the finger on what was the exact issue that was developing underneath. But, you know, unfortunately, that's not very easy. We need to go and rely upon what we believe as an experts should have been the correct design and is proper in the area and the standards that they follow. But without specific records, sometimes it's very difficult. It's not as easy as in the US to, even though it's not easy here either, to point out to the problems. Yeah.
Thank you, Nick. We wanted to have a period of about 5 to 10 minutes towards the end of the program for questions. There's been some questions on the chat, and I think that some answers have been provided. But If there are any questions that anybody would like to pose to the panel at this point, would be great. We have a few minutes for any questions or any final comments from anybody on the panel. Scrolling through it, don't see any questions. This is the first episode of a series, and I hope that you will come back and join us for the future episodes, where we will use the same format in the sense of drawing comparisons between our experiences and legal concepts in construction, as well as practical applications and issues in the U.S. and in common law jurisdictions, and their translation, for lack of a better term, or lack of translation in civil code jurisdictions, as well as some practical information about how to address the differences and how to reach the same strike the same level of risk that our clients are comfortable with when they go south of their border and engage in projects in those regions. If there are any other questions, we'll thank you on behalf of the forum and Division 8 for joining us today, and we hope that you will join us in the next for the next episode, which will be announced in the next I think 2 or 3 weeks. For the closing and for the rest of the way in driving us home, I'm going to ask Amy Phillips to please say a few words.
I just wanted to say basically the same thing. So thank you all for joining us for the first Bridging of Americas. And on behalf of the ABA Forum on Construction Law and International Construction, we truly appreciated you all joining us. I want to specifically thank Robyn Miller, Jerry Brodsky, Roberto Hernandez-Garcia, Bill Quatman, and Nick Saenz. If you have any questions, feel free to reach out to Richard, me, or one of our panelists, where we'll happily answer the questions for you. Please do consider, if you're not already a member, joining the forum. As a 20-year member, I can tell you it is one of the best places I've ever been to get to know our colleagues and friends. And I'm going to take a lesson from Richard Wong and say thank you, obrigado, gracias, y merci beaucoup, and goodbye. Thank you.
Thank you.
Thank you.